Everyday injustice. Too many wrongful convictions. Corruption has infected the criminal justice system, leaving too many people helpless, fighting for their lives. Instead of receiving justice, people suffer. Is that why they say justice is blind?
Today on Everyday Injustice, we're talking with Lauryn Barbosa Findley, who is the clinical supervising attorney at the Northern California Innocence Project. And she just helped to free Jose Olivares. Tragically, yet another one of these shaken baby cases. We're covering a shaken baby case as it's going through the court. And one of the interesting things is the judge actually warned the prosecutor, hey, if you don't want to end up on the Innocence Project list, you better watch this case. So, some stuff is sinking in, but these cases are still happening. So tell us the story of Jose.
Yeah, so Jose was a new father in 2011. He had just had his son Damien with his partner of about a year and a half. His partner had a child coming into the relationship, and he was about 2.5-ish when Jose and his partner met, and Jose quickly became a big part of the child's life and really became a father figure to him. The child called Jose daddy, and Jose really considered him his son, along with his 3-month-old son at the time. Jose had gotten home from work on what seemed to be a fairly normal day. His partner decided that she was going to go out and pick up food for their family, and left the child in the bedroom asleep, and Jose was basically just relaxing after getting home from work. Mom realized she forgot her credit card, returned home, and the child was still asleep on the floor. Within 10 to 15 minutes, she got a frantic call from Jose saying that something had happened to the child and that she needed to come home really quickly. What ends up coming out is that Jose was on the bed when his partner left the house, which kind of caused a little bit of commotion. So the child woke up and said, "Hey, where's mommy? Where did mommy go?" And Jose said she would be right back and invited the child up onto the bed to play with his toys. They were watching Transformers, which was his favorite movie. And Jose stepped out of the room, told the child to stay put. He would be right back. He's going to go to the restroom. And when he got back from the restroom, he found the child on the floor, acting abnormally and crying. And Jose immediately called 911. His other family members were present in the household, and they tended to Isaiah and waited for 911 to arrive. And that's kind of where a 13-year-long nightmare began, not only for Jose, but for his partner, for his whole entire family. It kind of began this horrible saga in not only just the criminal legal system, but also in child services and that whole thing.
So I guess there are two main questions I have based on that. One, I think, how do they arrive at their diagnosis that this wasn't an accident or wasn't a health issue, which is actually fairly common that there are these undiagnosed health issues. That's the issue we're dealing with in a case that we're covering right now. But why did they decide that this was a shaken baby case rather than something else?
So I'm sure, as you probably have heard quite a bit and your audience might be familiar, this shaken baby diagnosis was really born out of a theory, and it still to this day remains a theory. It was born out of a hypothesis from a doctor that when you see these certain intracranial findings, which are findings just inside of the skull, inside of the head, When you see these findings, that the only possible explanation for these findings is abuse or shaking. At first, it was only shaking, then it evolved to shaking and impact. And the name has evolved also. So, shaken baby syndrome is where it originated. It evolved into shaken impact syndrome when they realized, hey, maybe shaking, the science came under question. And they realized, hey, maybe shaking actually, like, these people are having legitimate challenges, that shaking can't cause these injuries. And then it evolved from shaken impact to abusive head trauma, which is now how it is referred to. So that's what happened is the child in the case, Isaiah went to the hospital, and he had, what's interesting in Isaiah's case is there was significant evidence of impact. He had a significant midline shift, which is the bleeding, the subdural hemorrhage, which is one of the 3 symptoms that were conclusively said to be only from shaken baby syndrome or abusive head trauma. The subdural hemorrhage was pushing on one side of his brain, which caused a midline shift. So he was actually immediately sent into the operating room for a surgical evacuation, which happens in some of these cases and doesn't happen in others. And typically it happens when there's evidence of impact, which makes a lot of sense if the only explanation seems to be that he had to have fallen off the bed, right? Because the last time he was seen, he was playing jumping on the bed. The next time he's seen, he's on the floor in the fetal position. So doctors did perform that surgery. And after that surgery, they realized that he had another one of those, quote, telltale symptoms, unquote, of shaken baby syndrome, which is retinal hemorrhages. And in his case, the retinal hemorrhages were very severe. And retinal hemorrhages, for just if anybody doesn't know, is this tiny microscopic bleeding behind the eyes. And they can be very small, microscopic, they usually are. And then they can also be a little bit more extensive, but that doesn't mean that there's more bleeding. It just means that there's bleeding in more areas behind the retina. And in this case, there was extensive, what they like to say, extensive multi-layered retinal hemorrhages. And there was optic nerve sheath hemorrhages also on autopsy, which contributed to the diagnosis. And then the last part of the shaken baby theory is brain swelling. And brain swelling is a very typical finding anytime somebody is hypoxic, which just means lacking of oxygen. It's very typical that their brain will swell. And there's been a lot of debate in the scientific community whether all of the findings that I just spoke about are all secondary findings, right? Are they all secondary to the bleeding that happens and this kind of cascade? There's not really any 100% answers in this space. And I think that that's why we're at where we're at. That's why we're able to push back now, because there's a lot more literature. And that's kind of what happened in Jose's case, how we were able to get his conviction overturned.
And why is the shaken baby diagnosis so common, and why is it so mistakenly common? I mean, it's one of the leading factors, I guess, in wrongful convictions, and we're still seeing it. It's not like it's going away.
Yeah, I think there's like a few competing ideas to that. I think that the first is that when a child dies, people want to have an answer. People want to blame somebody. And I think that a lot of times a simple answer is that somebody must have done something. But what medicine has shown, as you were talking about, is there's so many underlying factors that can cause the findings. And there's so many different accidents and infections, pneumonia, meningitis, all of these various things can actually mimic exactly the findings that were said to have been only shaken baby syndrome. And I think there's this really strong and powerful narrative, right? When a person goes before a jury, a doctor goes before a jury, and there's a dead child, and they're able to say the only way that this could have been caused is by abuse. That's really powerful. That comes off to a jury as extremely powerful. And this person has all of these fancy qualifications, and they're using all of these really big words to explain medical processes that, you know, the average layperson can't really understand. And it just all seems really credible. And I think that most child abuse pediatricians or people in this space are coming from the perspective that they are doing work to protect children, that they are doing, they're the last stance, they're the last ones that can advocate for somebody who can't advocate for themselves. And from that perspective, it's understandable why they believe so strongly in what they believe in. But at the same time, when you start deconstructing their ideas and you start deconstructing the evidence basis for, you know, the hypothesis that they're hanging their hat on in a lot of these cases, there's really just not a scientific basis there. And you can look at even who's considered the father of shaken baby syndrome. His name's Dr. Norman Bethkelch. He came up with the hypothesis back in the 70s. And when he found out that his hypothesis was being used to put innocent parents in prison without telling the jury, without telling people that this was a hypothesis, he was horrified. And it really has just cascaded on from there. And if you think about from the 70s until 2024, that's 50 years of this hypothesis really being sold as fact and being the chief arbiter, really, in these cases. The medicine is the chief arbiter. The medicine actually proves the intent, right? The medicine proves everything in these cases that needs to be proven in order to find somebody guilty. So I think that in that way, it's really similar to some other cases where the intent is, some other instances where the intent is baked in, but there's not very many instances that are like that. You know, most of the time the prosecution has to prove different elements. The prosecution has to put the pieces together in order for a jury to find a person guilty. In these cases, all the prosecution has to have is a doctor come up and say, this is shaken baby syndrome, and the entire case is proven just by that diagnosis. And that diagnosis, like we've talked about, is really just a theory, really just a hypothesis, but that diagnosis proves the identity of the person, because whoever was the last person with the child is going to be the person who is charged and convicted in most instances. And it proves the intent, right? Because they say that this kind of shaking had to have been so violent that the average person would have known that it would cause the harm that it ended up causing, right? So it makes the whole case for the state. And I think that that's part of why it has been so successful and why there are so many wrongful convictions is no matter what this person's character is, no matter if this person was the most loving, gentle, kind, compassionate father or caretaker or mother, the jury can't give credence to those facts because the doctor stands up there and says, well, the only possible way that this could have happened was abuse. And I'm telling you that with the absolute certainty. So they're really tough cases in that way.
Yeah, and one of the interesting things I think about this particular type of wrongful conviction that makes it so tricky is that this is a conviction for a crime that didn't happen. So it's not like they got the wrong person. And you'll be able to prove them innocent because you find the right person or because there's DNA. In this case, you got to prove that the medical diagnosis is wrong. And at best, in some of these cases, it really comes down to competing experts, and then you're asking, a trial level, a jury to weigh between these experts. That's assuming they get, sufficient defense that they actually put on their own efforts, which is another issue. So, I mean, this makes it really tricky to undo these things, right?
Yeah, it does. And even at the level that we're at post conviction, we still come up against that. We still come up against people who are very much wedded and indoctrinated in the science that has been, the dogma for the last 50 years, and haven't critically looked at the evidence base and say, well, this is what I was taught in medical school and this is what everybody else around me thinks. So I'm going to continue with this narrative. But the great thing for us is that there is a lot of medical literature that has developed that does, from a common sense perspective, does really undo a lot of the building blocks that were the foundation for this diagnosis, which I don't even really like calling it a diagnosis, because it's really not a diagnosis. It's a theory, or, a hypothesis. But thankfully, a lot of people who decided, we need to look critically at this thing, have put out a lot of medical literature that is useful in, what you're referring to, which, in the legal world, we call it the battle of the experts, right? And it's something that the court always, the court will refer to quite a bit is, we've had cases that we've looked at now post-conviction in this space that the doctors are all there, and the court literally says, well, this is going to be a battle of the experts. And that's really hard. I think that's really hard for a jury. And then you have all of these other ancillary issues that come up, and it's really easy. It was really easy for many years for the prosecution to paint experts that were calling the diagnosis into question. Really easy to paint those experts as child abuse denialists. That's literally what they were called. They would say, oh, these child abuse denialists just go around the country and are being paid by the defense to just say whatever. And it was really hard to start. It was really hard for a lot of these people who were doing amazing work trying to push back on this theory. It was really hard for them to gain traction. And I mean, there were even medical doctors who were completely blackballed by their industry, by their specialties, basically. And now they are just finally being vindicated. And I would, like to just take the moment to acknowledge Dr. John Plunkett, who was the first one in this space to say, hey, shortfalls can cause this. I did all of this research and I'm looking in the consumer reports, and there are all these playground falls that have caused the same kinds of findings. And this paper came out in 2001 or 2003. I can't remember if it's 2001 or 2003. It's one of the two.
20 years ago.
Yeah, 20 years ago. And he was completely blackballed. He was called the child abuse denialist. He was the chief person that all of these people would basically make fun of and say he was a quack. And may he rest in peace. He's now passed away, but he did this work for the last decade, more than a decade, 15, 20 years, trying to get families not to be convicted, and then also to reverse wrongful convictions. So he's a giant, and I always want to honor his legacy whenever I speak about it.
So I kind of set this up backwards because I wanted to kind of lay out exactly the difficulty of these kinds of cases before we dive into this. And so at what point do you become involved, and how do you get involved in this case?
Yeah, so our organization, the Northern California Innocence Project, gets involved in cases post-conviction. So we won't get involved until after the direct appeal. So after a person is convicted in our criminal legal system, They have an automatic right to a direct appeal, which is your appeal based on procedural errors in your trial. That can't be anything outside of the record. It has to be everything only inside of the record. And so after that point, typically direct appeals are denied. 7% of direct appeals are denied. And then our clients, our potential clients, usually typically write to us. In this particular space, in shaken baby syndrome, abusive head trauma convictions, we actually did it a little bit differently. Typically, clients write to us and ask for help. But in this instance, I actually, when I was a law student, I worked with NCIP, the Northern California Innocence Project, and my supervising attorney, Paige Caneb, who is amazing and
We've had her on a few times.
has a wealth of experience in shaken baby syndrome cases. She really is like a national expert. She's written law review articles on it and done a lot of work in this space. So really it was her that she kind of got me outraged by the injustice and double tragedy in these cases, right? Like a parent loses their child, your whole world is crushed, and then you're blamed and convicted for murder, right? I truly can't imagine a worse tragedy. So she got me completely enraged, and I wanted to do something. So we, her, Todd Freeze, and I came up with a proposal to submit to a fellowship, for a fellowship funding. And we applied to Equal Justice Works, which is a really awesome fellowship funding organization, and we ended up getting picked. And my fellowship was funded for 2 years by Fenwick and West, the law firm. And the project basically was to identify and litigate shaken baby syndrome convictions. So instead of clients approaching us and asking for help, we sifted through Westlaw, other legal databases, and found cases, all the cases that we thought rested on the SBS AHT theory. And then we whittled those cases down to cases where we thought that there were wrongful convictions. And then we started contacting people. Some of the people were in our database, in our system, from having contacted us before, but we just couldn't help them at that time. But a lot of people, like Jose, a lot of people had never reached out, they weren't in our databases. So we affirmatively reached out and said, hey, we're looking at the science, and the science has changed a lot, and we want to see if there's anything that we can do in your case. Is there any, could you send us your documents, basically? I think that we got all of Jose's documents in 2021, and that was from his family. His mom held on to all of his legal paperwork, and we dove into the transcripts and went from there.
And so how did this thing play out in the courts?
Yeah, so in 2022, we ended up filing a habeas petition in Los Angeles County. Our habeas petition was rested on the opinion of a new expert that we sought out, an expert that conducted an extensive review of Jose's case and a review of the medical evidence. And really it rested on the changes in the literature and how that influenced her opinion that it was actually more likely that the child in this case suffered a shortfall than it was that he was abused. And that's actually not that common in these cases, that an expert will go that far to say that it's more likely that the other cause happened. It does happen, but if you're just thinking about science, and I appreciate a lot of doctors' respect for science, is you can't really say for sure what happened in a certain instance, right? So saying that it was more likely it was a fall in this case was all based on the circumstantial evidence. And the circumstantial evidence was that there's absolutely no history of violence at all. Jose was a loving, gentle caretaker. Everybody said that. There were multiple other family members in the house. The timeline was very, very short, in which Jose was alone with the child. And unlike a lot of shaken baby syndrome cases, the child in this case was almost 4 years old. He was 4
Yeah,
years
it's
old.
unusual.
Yeah, he was 40 pounds, 41 inches tall. There wasn't a single mark on his body. There was no evidence that he
And
had
no
been
history of abuse or anything else. Like,
nothing.
this isn't like a 2-month-old.
Nothing. Exactly. So it was very out of the ordinary in a lot of different ways. And our expert specifically noted that. So we basically filed a habeas petition based upon her opinion. We filed a habeas petition based on her report, and her report, like I said, was a review of both the case facts and in this case, and then also just the larger body of medical literature and where medical literature is at today. So basically evaluating the case under today's scientific knowledge. So we used 3 different habeas claims to say that Jose's conviction should be overturned. We filed based upon false evidence, the idea that false evidence was used in Jose's conviction. So the habeas petition was based on 3 different claims. The false evidence, which is basically saying that false evidence was introduced against Jose at trial. And that claim is based upon the fact that all of the experts at trial said that the idea that the injuries in the case could have been caused by a shortfall was absolutely impossible, and only an accident that was equivalent to a multiple story fall or a motor vehicle accident could have caused the injuries in this case. And absent those accidental injuries, it could only have been caused by abuse. And that type of testimony is something that we see repeated over and over and over and over again in these cases. That specific language about it had to have been a 2 or 3 story fall or a high-speed motor vehicle accident. That's the only accident that could cause these types of findings.
And again,
I'm
that's
sure it sounds very familiar to you.
the scary part of all of this, is that assumption leads to a conviction, which is really hard to overturn. And these are serious charges. I mean, you don't get just a few years for these charges.
You do not. That's exactly right. I mean, just a quick sidetrack is in California, we have what is called 273AB. And 273AB is a charge, which is a general intent crime. It's a general intent charge. You don't have to prove any kind of specific intent, but it results in a 25 to life conviction. And to my knowledge, I think that it's the only general intent crime that you can get a life sentence without having to prove any specific intent, which is just really scary. It's child abuse causing death under the age of 8. That's the language of it, which is just so scary.
So you file this, and
I have 2 more claims if you want me to go through those.
Yeah.
But so we also filed upon new evidence, which is that one, Dr. Melinek's opinion, our expert, is new evidence saying that this could have been caused by a shortfall and actually more likely was caused by a shortfall. And then there's also new evidence in the form of medical literature. There's a dozen or more pieces of medical literature that show that a shortfall can in fact cause these exact findings. So that was another piece of new evidence that we were relying on for our new evidence claim. And then finally, there's a significant dispute claim in California, which is basically could be considered like a junk science law, very similar to what Texas is litigating right now in Robert Roberson's case. It basically is that a significant dispute has developed or further developed as to the basis for scientific opinion, which the expert relied upon at trial. So we filed under all three of those claims: false evidence, new evidence, and a significant dispute.
And then how does the DA's office in LA react? Because they have a reputation for being more progressive. Are they supportive of this, or did they fight you guys?
So what ended up happening is we filed, and Judge Ryan, who is the habeas, he's in the habeas litigation. He's in like the habeas unit in Los Angeles County. He issues an order to show cause. And we went to the Los Angeles District Attorney's office and asked, would you like to talk about this case? And eventually we got into contact with the habeas litigation unit, which is actually a unit that was started by George Gascon. And we've worked with them quite a bit on our habeas, on our post-conviction cases, basically our innocence cases. And they started investigating alongside of us. I don't think that they certainly did not come into it with the same perspective that we had, but we were really steadfast on the facts that, one, this isn't your average shaken baby syndrome case in a lot of ways. Two, shaken baby syndrome as a theory is completely flawed, and we can show you all the ways that it is. And three, there's all of this new evidence, the exact findings that were relied upon at trial to say this was abuse have been proven up and down throughout the literature that they can result from shortfalls. And another important piece is that in 2020, the American Academy of Pediatrics finally came out and said, actually, after giving guidance since 2001 that shortfalls don't result in the same findings seen in shaken baby or abusive head trauma, they finally gave the guidance that, it's rare, but shortfalls can cause the same constellation of injuries, which were once believed to only have been attributable to shaken baby syndrome. So we presented all of this evidence to them, and they basically said they would take it under advisement and that, they had to conduct their own investigation. So they did. They began conducting their own investigation. They spoke with experts. And so what ends up happening is they go to one of the original experts, who was the forensic ophthalmologist. So this is the guy that's focused on the eyes and the bleeding behind the eyes and in the optic nerve. And he ends up saying, under today's understanding, I've looked at all the literature that they've presented, and I agree that he should have habeas relief. And the evidence has changed in really significant ways. I can no longer say that these injuries could only be caused by shaken baby syndrome or abusive head trauma, because in all of these instances, it has been proven that these findings behind the eye could come from a shortfall. And he specifically referenced all of the same circumstantial evidence that our expert pointed to as being really significant in this case. All of the circumstantial evidence that was really favorable to Jose and really favorable to our argument. I'm not going to go through it all again, but he thought that it was all really powerful and all led to a similar conclusion as our expert came to, in that it is possible that this was a shortfall. And not only was it possible, but based upon all the other facts of the case, it actually seems more likely that the injuries in this case were the result of a tragic shortfall. So then we decided that we would basically squash our original habeas petition, and that the Los Angeles DA's office, the Hablet unit specifically, would file a joint habeas petition on behalf of both of our organizations, in which they conceded that false evidence was brought against Jose at trial based upon their expert, that forensic ophthalmologist's repudiation.
And let me ask you this question, and we're getting toward the end here, but I feel like this is an important thing because they're making basically a subjective assessment on these cases, which I think is really problematic anyway. But then, what role do you think implicit bias played in this case?
Giant, a giant role. I think that, so as I kind of not alluded to, but as we spoke about earlier, we did this on a really large scale, right? We're looking at cases all across California for the last 50 years. And we haven't gotten our numbers boiled down. And we know that we have some biases in our data, like not biases that we're picking in like a confirmation bias way, but that's like a statistical term for that we might not be including the whole world of data that we would need to make really strong statements. But I will say it was very disproportionately people of color that we found in our spreadsheets, and people of color that we found were being convicted under this this theory. And as everybody can now hopefully acknowledge, our criminal legal system is heavily disproportionately disproportionately impacts people of color, and specifically Black folks. And that seems to be even more prominent in these cases. And what's interesting is when we first started talking about this, a lot of people are like, oh, is it a lot of, like moms with postpartum? And it's like, no, actually, it's a lot of dads. It's a lot of young dads who are Black men or Latino men who have been caught in the web of this system, which judges them under a completely different lens than a well-to-do white family who brings their kid in with some kind of issue going on. And I am so glad you asked that question, because it really can't be understated how much bias goes into the decision making, not only of treatment of these children, but just the entire investigative process is completely different. What they choose to do in terms of genetic testing, or in terms of all of these niche things that may show, as you were alluding to, that there's some but there's some very rare thing happening in this child's body that's causing this type of reaction. If it's a white family and they're lawyers, then they're going to think, oh, there's no way that this family would have abused their kids, so we have to get to the bottom of what's happening here. If it's a young couple of color who is of average means, low income, working family kind of thing, that automatically is the first assumption. And they're not going to go and do the genetic testing. They're not going to go and figure out if there's some underlying thing. And they're just not going to believe that it was a shortfall, period. They're just going to dismiss that flat out. And, it couldn't have been a shortfall. And an interesting thing is, if you look at any, social work or medical literature about diagnosing abuse, poverty and race are literally outlined as risk factors for abuse. And that's guidance that's given to social workers and doctors. So they're already coming into these situations with the lens that who somebody is and what their level of means are creates a risk that this child is more likely to have been the victim of abuse. So there's just so many levels of implicit bias, whether that's in the medical field, whether that's the social workers who are evaluating these cases at the same time. And DCFS, or Child Services, CPS, is a whole other ball of wax that is really hard to undo. But the commonality is that poverty and race are those risk factors, as they say, for abuse, which is absolutely wild when you step back and think about it, and just completely unfair. And that's why these super disproportionate results end up happening. and it's really tragic.
Yeah, so let's skip to the end here, the happy ending. He gets released in early October.
Yes. So I believe it was September 19th. Um, Judge Ryan granted our joint habeas petition. So that meant that Jose's conviction was reversed and vacated. So his 2014 conviction has now been thrown out based upon the facts that it was the product of false evidence. And that's the happy part. Then it kind of, all of the celebration and happiness is slightly dampened by the fact that the district attorney's office, their family violence unit, is contemplating whether or not they want to move forward with a retrial of Jose. Nobody in Jose's life is supportive of this retrial, and that's including his partner at the time, who they're no longer together. His partner has moved on, is married, has a child with somebody else, is still steadfast in her support of Jose and steadfast in her support of his innocence. And so there's not a victim's family that the district attorney's office in this case is advocating for. The victim's family in this case does not want to see a prosecution move forward and has always believed that the original prosecution was wrongful. So the Los Angeles District Attorney's Office, that's where we're at now, is Jose is basically, we were able to get him released on a very nominal bail that we were able to help get some funds. His family contributed, and we were able to help get some other funds together to get him out on bail. The judge we're in front of has set a pretrial hearing for November 7th. So hopefully we might get some more information about where the district attorney is at. They were going to go back to some of the original experts at the trial and basically see where they stand and decide what they would like to do in this situation. And obviously we're hoping for a full dismissal in this case. There was a very similar case in some ways, but also not as similar in the fact that Jose's case is just so strong in terms of circumstantial evidence. Not that the other case wasn't, but just Jose's case is really a really strong case for innocence. And that other case was reversed by the same judge based upon ineffective assistance of counsel because that attorney didn't call proper experts. The case, I think, was reversed in 2021, and the Los Angeles District Attorney's Office decided to retry him, and he was acquitted on all counts. So we've brought that up a few times in our discussions. Just it doesn't seem prudent on their behalf in some ways, but also it just doesn't serve the purpose that the district attorney purports to serve, right? It doesn't serve the purpose of protecting the community. Jose is not a danger to the community. He didn't do anything wrong. He was a law-abiding, hardworking citizen just trying to do the best by his growing family at the time. And really, he is not a danger to the community. He wants to get back and reintegrate and work again and just build a relationship with his son, who's now 13 years old, who was 3 months old at the time that all of this began. And there's no victim or victim's family that is pushing the district attorney to continue to call Jose something that he's not and to accuse him of something that he didn't do. So it's a question for them, I think, and we don't quite have the answer yet to that. So we're hoping that we will get a full dismissal and that Jose and his family can finally close the chapter on this really horrible nightmare. There's a whole bunch of other things that happened to Jose and his family in the interim that we really didn't even get into, but his family has been through a ton of trauma, and it really just reverberated to his entire immediate family. Really went through an undue amount of trauma because of CPS and because of the Los Angeles Police Department.
All right, well, we're out of time. We've been talking with Lauryn Barbosa Findley, who's the clinical supervising attorney at the Northern California Innocence Project. Been talking about shaken baby syndrome, which I'm still really troubled by, and the case of Jose Olivares, who goes back to court November 7th because he hasn't been through enough, apparently. This has been Everyday Injustice. I'm your host, David Greenwald. Join us again next time for more tales from the injustice system.
Thank you to George Powell and Norman Mousequake Barrett for the use of our opening, Everyday Injustice. You can see more of George's music at www.justiceforgeorgepowell.com.